What's up, everybody? And welcome in to some more discussion on the day of the hearing. And I actually think it's a pretty significant hearing here in the Kohberger case. So much to be decided. This could have some profound effects on the case. We're going to break all those down, answer all your questions on today's episode. The reason I'm 1 minute late is we just did a pretty funny short to help us illustrate the difference between the probable cause standard and beyond a reasonable doubt when comparing those burdens of proof. Now, that short is going to be posted right after this video, or it might be posted during this video. So as we read through these motions and hear the state argue what the difference is and specifically why it's important that under the grand jury indictment process, it needs to be probable cause, not beyond a reasonable doubt, that the way the defense was arguing, that illustration I think will help you, especially my people from Chicago. I'm sure there are going to be people that disagree with me from Cleveland, Ohio, maybe Los Angeles, but I look forward to hearing you respond to that short where we really talk about the difference between probable cause and beyond a reasonable doubt. But on today's show, we're going to talk through a couple new documents that have been filed. One that I've already mentioned, the state's response to the defense's motion to dismiss because of that wrong standard in the grand jury instructions. And then we're also going to briefly talk about yet another affidavit filed in support of this IgG DNA evidence that the defense is currently putting witnesses on the stand during a hearing, trying to prove they need this information. The hearing's going on right now, but it's not being live streamed. Hopefully the video and recording will be dropped in its entirety later. And if so, maybe I'll do a reaction to that or a summary of it tomorrow or Monday. But let's get into what's going to be argued about in this hearing. And at the end of the episode, after we go through these documents and talk about what's going to be argued, I am going to give you my thoughts on how I think this is going to go down, what I think the outcome is going to be. So before we jump into some of the new documents, hit that like button and let me know you're here for the Kohberger content. But I'm going to run through what we're going to hear at the hearing or what's going to be determined at the hearing first. And in the comments, put how you think the outcome is going to go. Which of these do you think will be granted? So first, what's the state going to hear, or what's the state's motions that are going to be heard today? The state's motion for protective order filed on June 16th. The state's motion to reconsider the order staying the time for speedy trial. The state's motion for a scheduling order, which basically means we're going to trial October 2nd. So if we're doing that, when do we have to have witness lists done, exhibit lists? When do we have to disclose our expert witnesses and provide expert report and finish expert discovery, depositions, things like that? And last, the state's motion to compel notice of defense alibi. So they want to know, does the defense have to give us more? Are you going to, as the judge, say you can't bring any more witnesses, you can't make any different arguments as far as alibi goes than what you have already told us? So from the state's point of view, that's what's happening today. Let's get the defense's notice of hearing up here now. So what is the defense having heard today? First, the third motion to compel, which is, in fact, the IgG DNA data with all of the affidavits in support of that. The defendant's second motion to stay proceedings. They want to stay the proceedings again for more grand jury issues. And the defense motion to dismiss the indictment on grounds of the error. Again, speaking about the probable cause versus beyond reasonable doubt standard that they felt was incorrectly instructed to the grand jury. So that's what's happening today. Those are the things being argued. Tell me in the chat which ones you think have the best chance of getting granted, or which way you think the motion to stay is going to go, which way you think the motion to dismiss that grand jury indictment is going to go, and which way you think the DNA evidence is going to go. Do they have to produce it or not? Those are the major questions before us that I'm going to give you my guesses to at the end. And it's based on the fact that we have looked at all of these documents together. We have read all the arguments. We've read the case law. We have seen all of that now, except for these last two documents. So number one, let's quickly look here at yet another affidavit or declaration by a DNA expert from the defense, which I believe one is on the stand right now. We're just going to read the last three paragraphs. The first 13 are basically what an expert she is, and how she does it, and what her job is, and what her credentials are. But let's look at the last three paragraphs here. First, let me pull it over here so it's easier for me to see. These database tools have known loopholes that allow a genealogist to see matches that have explicitly declined to participate in law enforcement matching, meaning law enforcement's going outside the rules. This is not a glitch in the programming causing this by accident. It is a standard feature within the tools that essentially tricks the system into displaying all matches as opposed to only those who have consented to law enforcement matching, which again would be law enforcement violating the rules. This is not a loophole, nor is it something that you will stumble upon. Using the tool this way requires effort and knowledge, meaning law enforcement would have done this purposely. And if you purposely violate the rules and the rights of a criminal defendant, judges do not take kindly to that. Paragraph 15. Databases for law enforcement cases require a fee be paid in order to upload the genetic profile. That is not the same for consumers who are not charged. Many in the field have been known to upload to these sites as a regular consumer to avoid paying the associated fees and to bypass having opted out of matches. In addition, some databases restrict law enforcement uploading cases. However, that has not prevented it from happening. So once again, law enforcement disregarding the rules and doing things they shouldn't. And lastly, she is personally aware that law enforcement has obtained results in ways prohibited by the terms of use and prohibited by their own policies. Now, the way I read this is she is aware personally in her experience. This is what she knows to be true. In other cases, she does not. I don't believe she means to say that that is what happened in this case. Okay? So I want to make that clear. So I expect she may be testifying today, or the court can just take her affidavit and decide on that. But sometimes they like to call them live. All right. Next, let's pull up the state's objection to the motion to dismiss here. And we're not going to read this entire thing, but we are going to discuss a number of paragraphs and parts and discuss kind of where we fall on beyond reasonable doubt versus probable cause, what it should be, what we think the court is going to do, and how we get here. So I am seeing a ton of comments about all of the gifted memberships, which is so awesome. I had a couple people reach out being like, the generosity is almost a competition in this group because people want people to feel involved and become members and things like that. So that's so awesome. And I appreciate everybody for doing that. Net Woman has kind of led the charge, and Nicole Wheeler for a long time, every time is just gifting stuff left and right to me, to all of you, Azam and Rebecca and Tom and everybody in here. There's way too many people to mention, but thank you all for leading by example, being generous, having fun, enjoying this content as much as you can, especially when we deal with such difficult topics. Okay, so let's get into, is that better? Yeah, that's probably the best you can see it. All right, we're going to start page 2, paragraph 1 here. The Idaho Supreme Court has held probable cause is the correct standard of proof for a grand jury. The defendant's argument that beyond a reasonable doubt standard applies to grand jury proceedings is in direct conflict with Idaho Supreme Court precedent. The defendant seems to acknowledge as much, but ask this court to recognize what he claims is the long string of error that led us here. So again, when we went through that long and laborious document that the defense filed, we were like, aren't they just admitting that they're wrong, but they're saying everybody's been doing it wrong for the history of all time. Defendant's request ignores one of the most basic tenets of our legal system. The Idaho Supreme Court has been and remains the final arbiter of the Idaho rules of law. The Idaho Supreme Court has declared that the primary purpose of the grand jury is to determine probable cause. The court is duty bound to apply that controlling precedent and reject the defendant's argument to the contrary. And this is not something that is suggestive to the court. This is basically something the court has to do. That's what the state is saying, and I agree with them. Somebody joked, Eden, about it being a competition. And I was just furthering that joke. Okay. So basically, the Supreme Court has already said this is the standard, and this court is bound by that. They cannot make another decision. And I tend to agree with that in this argument by the state. All right, page 5 here. All right. Section 191107 sets the standard of proof for grand juries at probable cause. So even the statute says this. All right. Even if the court were writing on a clean legal slate, meaning the Supreme Court didn't already tell you what the standard is. The statute relied on by defendant sets the standard of proof for a grand jury at probable cause. Statutory interpretation begins with the statute's plain language. The statute is considered as a whole, and words are given their plain, usual, and ordinary meanings. Words matter. Definitions matter. The Idaho Supreme Court has also adopted the rule that when a statute and rule can be reasonably interpreted so that there is no conflict between them, they should be so interpreted, rather than interpreted in a way that results in conflict. So it's like if all this makes sense, we go with what makes sense. What we don't do is nuke the whole system because there's a way to misread a phrase or word into where it makes sense with nothing else we've ever done, but it benefits us in this situation. Now, I'm not saying lawyers haven't tried to do that in other circumstances and maybe even one, but generally speaking, this is correct. This is the correct way as how we're supposed to read the laws and the statutes. Idaho Code 191107 and Idaho Criminal Rule 6.5 share the same title and address the same issue: sufficiency of evidence to warrant an indictment. The rule explicitly sets the standard of proof at probable cause. Do you see how this is a lot easier to follow? Because this is how it's supposed to be done. This is how the rules work, not necessarily the way the defense did it in their motion. And I'm not calling out the defense. I mean, people have said, oh, you're too defense friendly in this case or too prosecution. This is just a specific argument they're making. And I think the defense is just dead wrong. And the state is showing how easy it is to argue the other side. The statute can and therefore must be read to do the same. Statutes and rules that can be read together without conflicts must be read in that way. The plain language of this statute states the grand jury ought to find an indictment when all the evidence before them taken together, if unexplained or uncontradicted, would, in their judgment, warrant a conviction by a trial jury. The Idaho Supreme Court has already rejected defendants' claim that the language requires the grand jury to find the suspect guilty beyond a reasonable doubt. So this has happened before. That's what we said. This has had to come up before, right? This is the first time any defense attorney has tried to make this argument. Well, the answer is no. Observing that an instruction setting the standard of proof for the grand jury as beyond a reasonable doubt calls for a greater degree of proof to justify an indictment than the rule requires. And if you're wondering, what's the difference really beyond a reasonable doubt versus probable cause? Again, John, I think that video is live and Jeff just dropped the link in our chat. So can you drop that link in the chat? So if people really want to see, and I think it's 2 minutes or less, the difference between probable cause, the difference between probable cause and beyond a reasonable doubt, I think it's an analogy. You've probably heard this argument before and how you could prove it. Catherine, ask and ye shall receive. Please plug your podcast. Yes, Friday mornings, every Friday, the video version of our podcast will post. We did Trial by Media, episode 2, Prosecutor's Right to a Fair Trial. So make sure that you go check that out after this video. And John, hopefully will be posting that link in the YouTube chat here so everybody can see it, and on Facebook and everywhere to go check that out after. It's kind of funny, but I also think it is a pretty good illustration as far as what can be proven by probable cause, even when there's arguments on both sides. It does not have to be everybody agrees, doesn't have to be perfect, versus beyond a reasonable doubt should be very, very easy and obvious. You'll see the link when John posts it. It's to a YouTube short video. Okay, so very good argument by the state there. And they talk about legislative intent and how you look at when the legislature talked about this rule. It was very clear the burden should be probable cause, not beyond a reasonable doubt. All right, let's jump down to page 8 here. Moreover, the assertion that Idaho incorporated sub silentio a beyond a reasonable doubt standard for the grand juries when the Idaho Constitution was adopted would be a surprise to Idaho's founding fathers. During the debate, here we go. They talk about some of the debate. The president of the Idaho Constitutional Convention advocated for keeping the grand jury system and stated that the standard of proof for grand juries in Idaho is probable cause. That is all. This is a quote. That is all the grand jury is entitled to do, to say that there is probable cause to believe the man is guilty. Okay. So again, pretty clear, dating back to the early days of Idaho, in direct contradiction to what the defense wrote. And you're probably understanding which way I am leaning on how I think this part's going to come down. All right. Even if Idaho, this is another section we're going to just read a paragraph of. Even if Idaho code and rule conflict, the rule controls and the results are the same. Even if they conflict, the Idaho court has the inherent power to make the rules governing the procedure in all of Idaho courts. When a rule and statute conflict, the question then becomes whether the subject of the law is substantive or procedural. Substantive law prescribes norms for societal conduct and punishments for violations thereof. It thus creates, defines, and regulates primary rights. In contrast, practice and procedure pertain to essentially mechanical operations of the court by which substantive law, rights, and remedies are effectuated. As a general matter, questions about standard of proof have long been recognized as procedural, not substantive, and the court makes those decisions. Okay? So, we talked about the substantive versus procedural in the last video, but I'm going to jump down, and now we're going to read these last 3 pages, 11, 12, and 13. Because I think you guys like some of the sass, some of the shots the lawyers fire back and forth. I want to make sure that, Genjo, thank you for this. I saw this question being asked. I don't know the answer. Here's the answer if you want to turn on gifted memberships. And we're actually going to record another episode of the podcast tonight before the end of the night. My dad, Pete, and I think. So anyways, you guys like when they kind of throw shots back and forth. I've read some from the defense. I've read some from the prosecution. I try to keep that fair and balanced. So we're going to read some shots the state takes at the defense's argument that, a lot of us were kind of side-eyeing when it came out. Defendant's motion should be denied as it rests entirely on erroneous legal theory, but it has other problems as well. As the defendant acknowledges, the statutes governing grand jury proceedings do not allow for a challenge to the instructions given to the jury. The statute that sets out the grounds on which a defendant can seek to set aside an indictment does not mention instructions to the grand jury, and the inclusion of specific grounds to challenge the indictment in the statute excludes the consideration of any other. The defendant claims the Idaho Supreme Court has adopted the theory that a defendant can challenge the grand jury instructions, but he cites for this rule a passage in Gasper that he previously labeled dicta, but it did not suit his argument. It seems that the state that dicta for the goose is dicta for the gander. Again, almost quoting some of the stuff the defense said, and they've kind of thrown these kind of shots back and forth. But assuming the Idaho Supreme Court did want defendants' claims in Gasper, the court merely allowed a defendant the opportunity to make a showing of prejudice. This defendant cannot do. In fact, he fails even to allege that the grand jury would not have indicted him on beyond a reasonable doubt standard of proof, explaining that in grand jury context, prejudicial effect comes only in the but for flavor. So what's interesting here is what he's arguing is, in order to even win on these grounds, you can't just say something was a problem. And there's a lot of appellate rules like this. You can't just say something's a problem. You have to say it's a problem that changed the outcome. And in this case, we even believe as the state, if the burden was beyond a reasonable doubt, they still would have indicted him. That's how confident we are. And the defense did not even argue that if that burden would have changed, they would not have indicted him. And here's why. And in order to show prejudice, they should have had to make that argument. Again, hopefully you can understand that. And if you need an illustration, the link has just been posted. If you need an illustration as to the difference between probable cause and beyond reasonable doubt. And they're saying that even if you take the first discussion I had, which was probable cause, and you apply the standard from the second one, you'd still be able to prove your point. And I believe some people would agree. The first discussion about who the greatest of all time was, some people believe it's beyond a reasonable doubt. Instead, defendant tries to short circuit his need to show prejudice by claiming where a jury has been misled as to the standard to the defendant's detriment, courts find fundamental error because the error goes to the foundation of the case and takes away any essential right. Defendant fails to point out, however, that every case he cites is referring to a trial jury being improperly instructed on beyond a reasonable doubt standard. Very different. As the court in those cases explained, improperly instructing the jury in that context is a fundamental error. So that would mean if they said, you just have to kind of be okay with it, or it has to be 51%. If that's how the state describes the burden of proof in a jury trial, in a criminal jury trial, if they say the standard proves beyond a reasonable doubt, that's just 51%. and the judge allows that. That's fundamental error. That's going to get overturned every time. The requirement that the state prove every element of the crime beyond a reasonable doubt is grounded in the constitutional guarantee of due process. Again, that's in a criminal jury trial, not a grand jury. Not even defendant's unorthodox theory goes so far as to suggest the constitutional guarantee of due process compels the use of beyond a reasonable doubt standard of proof in the grand jury. Moreover, defendant's suggestion that some errors in the grand jury process necessitate dismissal of the indictment without any inquiry into the potential prejudicial effects cannot be squared with Idaho Supreme Court precedent. The high court has held that any error in the grand jury proceeding is harmless once the defendant has been afforded a fair trial. So it's like they go to trial, and if it's fair and he's convicted, doesn't really matter what happened at the grand jury. And kind of makes sense. It feels unfair to me. Like at my core, that feels unfair. You guys let me know if you agree. But at the end of the day, if you get all the heightened rules and protections of an actual trial, and that is found to be a fair trial, and they did find you guilty beyond a reasonable doubt, who really cares if the grand jury would have found you or would have indicted you by probable cause or even beyond a reasonable doubt? Because the trial jury found you guilty beyond a reasonable doubt. Now, sucks to think, especially if you're innocent, there should be some like civil remedy or something for you if they violated your rights in the grand jury and held you in prison for all these years. But if, I understand part of this, but it hurts me deep in my soul to think that we would just hold people even though the grand jury process was unfair or incorrect. I don't agree with that argument, even though logically it makes sense. Logically, I should say, if you're guilty beyond a reasonable doubt, then you would have been indicted by a probable cause. Finally, the defendant's explanation of what would happen were this court to set aside the indictment is misleading. He suggests this court could simply treat the indictment as a presentment, but he cites no authority for the proposition that this court can do so. He then suggests that if the court decides to set aside the indictment, it would have to determine whether the matter may be resubmitted to the grand jury. The statutes defendant relies on do not say what defendant claims. So misstating what the statute and the law says is a pretty good shot. Those statutes allow the court to direct that the case be resubmitted to the same or another grand jury. If the court directs the case to be resubmitted, but neither statute even purports to empower the court to prohibit the state from presenting the case to a grand jury again, the law expressly states the opposite. An order to set aside an indictment, as provided by this chapter, is no bar to a future prosecution for the same offense, and whether the state initiates that future prosecution via a complaint or an indictment is left exclusively to the prerogative of the prosecuting attorney. And they're right about that. That's what the rule in Idaho is. The state gets to determine. We talked about this at length. At length, we talked about whether or not it's up to the state or defendant, whether it's a preliminary hearing or a grand jury indictment. And the point is, it's up to the state. Period. It's up to the state. Okay, I'm going to answer some questions, and then I'm going to bring the motions that are being heard today back up on the screen and discuss how I think they are going to come down. Rubber Toe, Peter, when you get here, how difficult is it for your firm selecting, dismissing potential jurors? YouTube makes it feel like most folks are heavily biased. Just wondered if that is your experience. So sometimes it depends on the case, depends on the jury. But what I will tell you is people are a lot more honest behind the keyboard with no repercussions than they are sitting in a courtroom talking to me. So I've got to talk a lot with them and try to get to know them and see, like, even if they're not saying something, am I getting the feeling they don't like my client or they like the other side better? Or, they've been sued before, so they think everybody's a snake oil salesman or ambulance chaser type of deal. You got to pick through some of that stuff. And if it's a criminal case, sometimes a lot of their other answers can indicate what they think about the important things in a case. Adam Ace, is it hard to believe that he might enjoy driving around, but for different reason than most of us would? Could give the defense confidence arguing that fact? Sure. I don't think it's even that hard to believe. A lot of people have said that they drive around at night, especially since COVID. I don't think that's the hardest thing to believe in the world. I just think that the state could potentially get around it with some of the evidence they have. Margaret, if he has an alibi, wouldn't he have offered it to avoid arrest? The state doesn't have to believe his alibi. Lots of defendants have alibis as they're sitting in prison because the state says, we don't believe you. We don't think you have enough credible evidence, or we don't care. An alibi is not an absolute get out of jail free card. It is still something that has to be proven, and that you have to prove to the state if you want them to dismiss the charges, or to a judge or jury, depending on what your trial ends up being. Why wouldn't DNA be part of his trial only? I don't know what you mean. DNA is going to be part of his trial. I don't know what you mean by only. It's got to be part of this process and the discovery process before it's part of the trial, because everything that comes in trial is part of the discovery process. D Fury, the judge will decide today, correct? There's a lot of decisions to be made. I don't know. A lot of judges in these situations reserve ruling until they have time to process and read through everything, listen to all the arguments, and then issue a written order later. So could be today, could be another day. Are you following the live tweets from the courtroom about witnesses? I was before I started doing this. And I know the defense attorney who specializes in using DNA evidence in cases was testifying, and we'll talk about that some when we get to how I think it's going to come down. Kirsty, this case has been pretty confusing at times. Thank you for breaking it all down for us. We appreciate you. Yes, it has. And I know there's plenty that I cannot make more easily understandable for you, but I do my best. Rebecca, Peter, you are just honest to a fault, not choosing sides. I try to be. I think that's the easiest way to do this stuff, and it's like, if I'm just looking at it objectively and trying to see it how I see it, regardless of who wins or who's coming out ahead, I feel like you can always stand pretty firm in understanding that's the opinion at the time based on the information we have. John, is it true Idaho still allows death by firing squad? So I heard that they were potentially thinking about reinstating that or reallowing that by choice of the defendant, and especially because they are low on lethal injection material. Who picks the grand jury? State attorney. Thank you, Melissa, for the super sticker. And welcome to a bunch of the new members, Pebbles, Karen. I saw some others that were gifted memberships, which is always so awesome. I appreciate you all for that. Okay, let me bring back up the notices of hearing so we can see where we are. All right, first we will start with the states. All right, the states motion for protective order, and on the other side, so I mean, these are kind of going back and forth, but DNA evidence. State's trying to file a motion for protective order. Defense is trying to file a motion to compel the state to turn that over to them. So my feeling on this is I think the court will end up compelling the state to turn over more evidence. Now, whether that's whether that's just a lab report, or whether that's actually what the defense is asking for, I think remains to be seen. But I know I saw some tweets earlier that the court's like, listen, if the state says they don't have it and you want to compel it, I can't force them to turn over something they don't have. There's got to be some trust in this process. I talked about this with JB. Some of you came from there and watched that as well. And to me, I feel like the fair and just outcome of these motions, the protective order and the motion to compel, would be to provide everything to the state surrounding the gathering, the searching, the use of DNA evidence, the building of the family tree, how they got there, when they got there, and who got them there. That's how I think this should come out. That does not mean they're going to find anything. That does not mean Brian Kohberger is going to find the smoking gun in this discovery. But I absolutely think the state should turn that over. So that's how I think and hope that one turns out. The state's motion to reconsider the order staying time for speedy trial. Okay, that's the second. This is a motion for reconsideration on a decision the court has already made to stay this course for 37 days. Now, we read this together. At the time, I didn't think the state was going to win this. And now with more context, the defense has actually filed a second motion to stay, saying, Judge, we need even more time because of what the state's doing surrounding this grand jury information. I would expect the judge to deny the state's motion to reconsider the order staying the speedy trial period. By the way, these are my opinions. These are not guarantees. I'm not a genius if I get these right. I'm not an idiot if I get these wrong. These are all up to the judge. It's judicial discretion. Number 3, state's motion for scheduling order filed on July 17th. So this will be granted, I guess, because I do expect the judge to tell them when things need to be done, set deadlines, give us a trial date, work backwards. I expect that to happen. I hope that happens. So I would expect this to happen. The only reason I could see this not happening is a timing issue. If there are a lot of witnesses and a lot of arguments being made, it's Friday afternoon, or it's going to be Friday afternoon there. So that's the only reason I could see maybe this not happening today, is the judge saying, we just don't have enough time to handle this. Next, The state's motion to compel notice of defense of alibi. This is the one that's hardest to determine. I could see the judge saying the defense has provided an alibi. They don't have any materials at this point or witnesses. If they produce them in the future, then that would be a more timely period for you to file a motion to potentially strike those witnesses for being outside the time period for the defense to file their notice of alibi with additional evidence or additional witnesses. And I will take it up at that time, as it is within my discretion to strike witnesses in the interest of justice. But I do not have to strike witnesses. That is not a shall in the statute. That is not a must. We read that statute together on this channel. So I would expect the judge to not limit the defendant's alibi at this point. I don't think he's going to strike the defendant's alibi. And I think he will reserve ruling on any future evidence that may or may not come forward. The defense may never produce anything corroborating the alibi. But if they do, I would actually expect the judge to allow it. So I'd be very surprised if at this point he would strike this or limit what the defense can present as an alibi. Okay, let's bring the defense's notice of hearing back up. All right, the defendant's third motion to compel. This is the IgG DNA evidence. Kind of already talked about that. I expect this to be at least partially granted, and the state has to turn over more than they already have, if it exists. The defendant's second motion to stay proceedings. So, the state's already asking the court to reconsider the first motion to stay. The judge granted that motion in hopes that this will provide enough time for them to deal with all of the grand jury issues. The court does not want to set the precedent of every month granting a 30 to 37 or however long it is stay, delaying the defendant's speedy trial rights, regardless of if the defendant agrees to the stay without waiving his speedy trial rights like they did the last time, which again, we read together. So my opinion on this, will the defendant's second motion to stay proceedings be granted or denied? If I was going to guess, I would guess denied at this point. If I was the judge, I probably would not grant any more stays until we get a lot closer to trial, or maybe within that 37-day period post October 2nd. And that's a question I get every day in the chat. Will this trial go October 2nd? I don't think so. It could, but I would be surprised. When does the judge rule on this document? Maybe today, maybe next week. Hopefully not later than next week. Everything's kind of expedited in this case because it's a speedy trial. So I don't think he's going to wait long. He may take the weekend and do it Monday. But I think at the latest, it'll be early next week. And last, the defendant's motion to dismiss the indictment on on grounds of error in grand jury instructions. This is the probable cause versus beyond a reasonable doubt, which is a big difference. If you don't believe me, go check out the link John posted in the chat. This one I feel most confident about, potentially, that the judge is going to deny the defendant's motion to dismiss the indictment based on these grounds. Again, denying these motions does not mean that Kohberger did it and he's guilty. Granting these motions does not mean he's innocent and didn't do it. So that's important to point out, that each individual decision by the judge, especially on discovery or motions to dismiss, is not a jury verdict. They're very, very different. All right, hit that like button if you guys haven't already. We've got a few more minutes here to continue talking about this case. I will look up some tweets and see if I can see anything worth responding to. As you hit the like button, I'm going to hit a few super chats here. Rebecca, C. Peter is fair and unbalanced. I think you mean balanced. That's why you are as popular as you are. Thank you, Rebecca. Adam, admire your time management, family, work, hobbies, YouTube. Yes, thank you. I pride myself on that and try to stay focused on it, or it can really spin out of control. Chief Shenanigan Officer, I saw your team name, I think is Chief Shenanigan Officer, or your email or something, is in the Fantasy Football League. Yes, I'm pumped about that. Anna, IgG has been accepted to identify previously unidentified persons. Could this affect the defense prosecution argument? If so, how? If the court feels the defense needs this to prepare its case appropriately, then he will grant it and force the state to turn it over. Now, if the state just doesn't have certain things, again, they can't be compelled to turn it over. So nothing's going to change the fact that the state just might not have certain things that everybody may agree is relevant and discoverable. All right, let me pull up my Twitter here and update it. The hearing's underway. Okay, let's get to some of the more recent ones. 8 minutes ago, back in session. The PowerPoint is in, but defense attorney has trouble with the technology. The judge says perhaps we should have another expert help with that, which garnered chuckles from the gallery, including the defendant. We can't see the PowerPoint from the gallery in the courtroom. Okay, this is all from Court TV, by the way. After a short break, now is defense witness number 2 regarding their motion to compel. Dr. Leah Larkin, genealogist. We read her affidavit together. Again, I'm probably not going to, under any circumstance, play this hearing in its entirety. What I'll probably do is kind of like I do trial day recaps, is pull little clips from the hearing, react to them, talk about them. We may listen to the judge's ruling in its entirety if, in fact, he does rule today. Again, but that'll happen either Saturday or maybe next week. My daughter and wife are going to some Taylor Swift thing on Saturday. So it's just my son and I. So maybe after he goes to bed, I will jump in and talk about this hearing if it gets posted. The state's objecting to this witness as a qualified expert as they haven't reviewed her proffered PowerPoint. Court takes 10-minute break so they can review. So what they mean is if you come to court and you have an expert and you didn't turn over the PowerPoint, the state has the right to look through this PowerPoint. They object. They take a break. State looks through the PowerPoint. Seems like the judge has allowed the PowerPoint at this point. And I have heard that these experts, and I don't know where I heard it. Sorry, it might have been JB or somebody read it to me or I read it on Twitter. And I heard that these experts, the defense is not purporting to call any of them at trial, but instead they are just specifically experts as to how they would use and why they need this IgG DNA evidence the state either hasn't turned over or isn't turning over or refusing to turn over or filing a motion for protective order on. Okay, let's see what else we got. In Mercer's testimony, we learned the DNA sample on the knife sheath was tested twice, and the defense should know about the details of this testing so they can challenge it if necessary. The minimum practice standard is that an attorney must obtain discovery of the scientific testing, particularly in a capital case regarding trace DNA. It's crucial to get that discovery because it informs the scope of testing and which experts to hire on the defense side to evaluate what was done. That's a good point. Without discovery of the testing database searches, as well as the family tree build out, the attorney can't investigate it. Thus, the attorney is not complying within their duty to investigate in a capital case. Very interesting. We need this just to determine what experts we need, Judge. And this is coming from an expert criminal defense attorney dealing with DNA in a lot of cases, I guess. So that's a really interesting argument that, again, all of this, I think, and all the affidavits we've read and all the information we've discussed together points toward, I think that the judge should compel the state to turn it over. I just don't know what they have. And what's also interesting to me is throughout this process, coming to the point of why they can't get this information in depositions. Why are they not deposing everybody, asking law enforcement about all of this? Because lots of times in cases, we'll depose law enforcement and they'll say, oh yeah, this is how we do it. And we're like, whoa, whoa, whoa. This is how you do it? You mean there's a paper file of this somewhere? Because we asked for this in discovery. You never turned it over, state. And the cop will be like, yeah, I have it. And we're like, what? State's like, well, we don't have it. It's not our fault. I mean, that happens all the time. Inadvertent sometimes on purpose, whatever. But in deposition, you can find a lot of things that maybe were not produced in discovery the way that they should have been. And that's why depositions are such an important part of discovery. Now, I will say in misdemeanor cases in Florida, you don't have a right to depositions. You have to actually file a motion and ask the court, can we depose law enforcement officers? Can we depose people? But in capital cases, I would think everywhere you'd have a right to depositions. But maybe not in Idaho. I don't know. I don't know the answer to that. I could look that up. I haven't yet. Let's see what else we got. First motion of the day is the defendant's third motion to compel, asking the court to order the state to submit discovery originally asked for on May 3rd. And again, May, June, July, August. They asked for this evidence on May 3rd. For 4 months, the state has not given it to them. For 4 months, they have not been able to talk with experts about this. Now, I know people are going to disagree with me. I know they're not going to like it. I know some of them think Ann Taylor's doing things for clout or just a delay. But if the judge determines that they are entitled to this evidence and they have missed out on 4 months of potentially scrutinizing it, investigating it, having experts look at it, and now they only have 2 months to do something. You usually have 30 days to respond to discovery. So we'll say they asked for it 4 months ago. Maybe they should have received it 3 months ago. So cutting their time by more than half to investigate, look through, have an expert look at, and use this evidence at trial. You're going to tell me that's not prejudicial? That's not potentially violating Brian Kohberger's speedy trial rights? Everybody knows he's got 6 months to prepare and go to trial. So if you're withholding evidence that the judge ends up determining is discoverable and potentially relevant, it's a problem to me. Now, it could be nothing. The state could have done everything right. Law enforcement could have done everything right. But let the defense have the time necessary that people that write the statutes and write the rules and write the laws and interpret the laws, they have all found 6 months is appropriate. That's the speedy trial rule. This judge has added 37 days, but still. And maybe the judge will say that's how it's been cured. You have an extra 37 days. So it's really only delayed 2 months or less than 2 months. And, that's not prejudicial enough for me to say his speedy trial rights were violated. So maybe the judge has already fixed this issue with that motion to stay, which again adds more context as to why I think he's going to deny the state's motion for reconsideration on that motion to stay and to rescind that period of time allowing the delay. When is it supposed to be over? I think it's going to take the rest of the day, basically today, this hearing. Channeling the heart, Barbara Joyce. I understand the independence of states, but it seems that the client's treatment can vary greatly. 2 examples: juror can take notes and ask questions. Some situations they can't. Sometimes they're sequestered more often in certain states. I know. That's the interesting thing. We don't want to be too uniform, right? Because we're individual states with, state government, and we want that separation of state and federal government, but it is confusing sometimes, and sometimes it does seem unfair. But people usually, and I say this knowing that economically sometimes it's impossible for people to move from one state to the other, but generally speaking, people choose where they live or their families do. And if you don't like the way the judicial process or the rules or laws are in your state, you do have the opportunity to move. I know I don't want the chat to get up in arms. I get that financially speaking, that can be impossible for people. But that's the theory behind the states having different rules. And what I'll say is, and that's one of the reasons we have this channel, is let's shed light on what those rules actually are. So many people don't actually know what the justice system is like in their state, civil or criminal. And it's very different from state to state. I mean, there's a lot of similarities as well. Azam, I need to rewatch. My brain isn't fully functioning yet in the first 30 minutes of the video. I'm good now. Sorry. Yes. Go rewatch as a clear mind, Azam, so you can get the full benefit of the video. Rebecca, thanks for the correction. Just got off at 0700. Serenity has, in fact, watched the short from the link that we posted. Hopefully, a lot of other people are watching it as well, because I thought it was funny. Asia. Thank you. Asia. Just to make sure I'm saying it right, because I always second guess myself. Chelsea, question. Peter, aren't depositions only in civil trials? No. Depositions happen in criminal trials as well. Go back and watch Murdoch. They reference tons of depositions. Now, cases like Murdoch that have civil and criminal elements sometimes have civil depositions that make it into the criminal case, but not every jurisdiction does allow depositions. A lot of times in federal cases, you can't depose certain people or anybody at all, depending on the case. Limited discovery rules in federal cases as well. It's crazy the difference. I should have my dad on to talk about how discovery is different in federal cases versus state cases. But like I said, in Florida, we're not entitled to depositions unless we get a court order or a judge tells us we can in misdemeanor cases, which are lower level cases. But I mean, I've had a week-long misdemeanor trial that ended in a hung jury. Would have been nice to do depositions in that case. Now, you can call witnesses and talk to witnesses and get recorded statements sometimes, but official under oath sworn depositions, not always. Over 5,000 people coming to hang out on a Friday afternoon. That is wild. Thank you, everybody that's come to join us. Please hit that like button and subscribe if you haven't already. Hit that reminder bell so you don't miss any of the other videos and you don't miss whenever I happen to go live talking about this hearing, either Saturday or Monday. Let's take one more look here at Court TV's Twitter to see if they've posted anything else. We can't see the PowerPoint from the gallery. We already saw that. Doesn't seem like there's anything else. I think I saw a picture that Andrea Burkhart is actually there. If you want to follow her for some reporting after the fact, sitting in the courtroom, which hopefully I'll be able to do one day in the Sarah Boone trial if it ever happens. All right. So it seems like that's all we've got for today. So again, I appreciate everybody that comes here to hang out, everybody that asks questions and comments. It adds so much context, what people understand and don't understand. I always say, if you have a question, somebody else probably has it too. We learned today, once again, words matter and definitions matter. Burdens of proof matter. Prejudice matters. Justice matters. And all of you matter too. I appreciate y'all so much. That's all we've got. I hope everybody has an awesome weekend. Hopefully there's some pickleball in store for me, maybe you too. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.